Welcome to this deep dive. We're taking the sources you shared and, well, trying to cut right to the heart of things.
Look at them really key judgments from the Supreme Court of India.
Yeah, roughly over the last 10 years or so, say 2014 to 2024.
And these aren't just, dry legal tests.
No, absolutely not. They genuinely shape daily life, democracy, even things like finding a job or family matters.
It's about understanding the impact, the real-world meaning for you.
The why and the so what behind these big decisions.
And the sources you gave us really show the breadth of issues the court handles. It's quite something.
Constantly balancing rights and needs, interpreting the Constitution for today.
Exactly. So shall we jump into some examples?
Let's do it. Let's start with something very personal: arrest. Your sources highlighted, well, a worrying trend.
Yeah, especially around certain laws, like Section 498A on dowry. Arrests sometimes felt almost automatic.
Leading to real hardship, right?
Ah.
Before any guilt was proven.
Precisely. And that's where the Arnesh Kumar case from 2014 comes in. The data was stark.
High arrest rates, but low conviction rate.
Exactly. It suggested arrests weren't always about solid evidence. Maybe, sometimes, a tool for other pressures.
So the court saw this mechanical arrest problem.
Yes, and stepped in. They wanted to prevent arrests that could ruin lives unnecessarily pre-trial.
Okay, so what was the fix? What did they actually require?
They mandated a police checklist. For certain offenses, police have to fill this out before arresting someone.
A checklist. What's on it?
Reasons. Why is the arrest necessary? They have to record it and give the accused notice.
The courts magistrates.
They have to look closely, too. Scrutinize the police reasoning, not just rubber-stamped detention requests.
So it's not just arrest because you can, but because you must, for recorded reasons.
That's the shift. Your sources had a good mnemonic for this.
Yes. Arrest smart. Makes sense. Justify, notify, get oversight. A big safeguard.
A very significant one for personal liberty. And it ties into the next point, bail.
Right. If an arrest does happen, how do you avoid someone just sitting in jail waiting for trial, sometimes for years?
Which brings us to the Satender Kumar Antil case, 2022.
This felt less like a new idea, more like strongly reinforcing something fundamental.
Totally. The principle that bail is the rule, jail is the exception. It's basic, rooted in the presumption of innocence.
But maybe it wasn't always being applied consistently.
The Antil judgment aimed to fix that with practical guidelines. For courts, for agencies.
What sort of guidelines?
Things like time limits. 2 weeks to decide regular bail, 6 weeks for anticipatory bail. Clear deadlines.
Okay, that's concrete.
And linking bail back to Arnesh Kumar. Did the police follow those arrest procedures? That now factors into bail decisions.
All aimed at reducing that huge number of under-trial prisoners.
Exactly, combating unnecessary pretrial detention.
The mnemonic here was SKA, speedy bail, keep liberty, avoid arrests. Captures that focus. Okay, let's shift gears completely. Democracy itself, electoral funding.
The electoral bond scheme. Very contentious.
It aimed for transparency in one-way banking channels, but created opacity elsewhere, right? Donor anonymity.
That was the core tension. Curbing black money versus, well, the public's right to know who funds parties. Hidden influence potential.
And the court's verdict in the Association for Democratic Reforms case this year, 2024, pretty clear-cut.
Oh, absolutely. Unanimous decision. They struck the scheme down.
On what grounds?
Violation of the voter's fundamental right to information under Article 19(1).
So knowing who funds parties is crucial for voters.
The court said it's essential. Vital for making informed choices, for free and fair elections, for accountability. Transparency trumped anonymity here.
Public right to know is paramount in this context. The summary, EBS, electoral bonds struck. Simple. Okay. From the very public to the very private, divorce.
Right. Sometimes the legal process itself can be, well, an obstacle, even when a marriage is clearly over for everyone involved.
Long waits, procedural hurdles.
Exactly. The Shilpa Sailesh case in 2023 tackled this. Situations of irretrievable breakdown.
And the court used a special power, Article 142.
Yes, it's unique power to do complete justice.
What does that mean in practice here?
It means if a marriage has truly broken down beyond repair, the Supreme Court can grant the divorce directly. It can bypass the usual waiting periods or need for mutual consent filings that lower courts require.
So it's about acknowledging the reality on the ground.
Precisely. When the legal process itself adds to the suffering, Article 142 allows the court to provide a resolution. It's flexibility for justice.
Cutting through the red tape, essentially. The mnemonic reflects that. SSVS-SC saves vexed spouses. A pragmatic touch. One last area, jobs. public recruitment.
Hugely important. Fairness in how people get government jobs.
And the Tej Prakash Pathak case is key here. Your sources mention 2025, but it builds on established principles, yes.
That's right. It crystallizes a crucial rule for fairness in selection processes.
Which is?
Basically, you can't change the rules of the game after the game is started.
Meaning?
Once the recruitment notification is out, the eligibility criteria, the selection method that's fixed, you can't suddenly alter it midway through.
Because people applied based on the original rules.
Exactly. Changing them later is unfair, potentially arbitrary. It undermines trust. Consistency is key.
Don't move the goalposts mid-match. Got it. The mnemonic. TPP, Tej Prakash Pathak. No post-process changes. Very clear.
So these are just a few examples, but they paint a picture, don't they?
They really do. Across personal freedom, democracy, family, jobs. So summing up from your sources, what's the big takeaway for you, the listener?
I think it's seeing the Supreme Court in action, constantly interpreting the Constitution for our times.
Balancing rights, liberty, information, fairness against state actions or societal issues.
Yes, and holding power accountable, whether it's police procedure, political funding, or recruitment fairness. These cases show the law isn't static.
It's alive, adapting, responding to challenges.
Striving, you could say, to uphold justice in a complex, ever-changing world.
Definitely something to think about as you go about your day.